Welcome back to SCOTUS Oral Arguments and Opinions. In the third of six episodes of today, we'll discuss the June 12th, 2025 Supreme Court opinion in the case called Martin v. United States, case number 24-362. We'll first walk through the syllabus, discuss a couple case implications, and compare how the oral argument debate about the scope of the court's review played out in the unanimous opinion and concurrence. Please note that this summary is read by an automated voice. The questions presented in this case are whether the Constitution's Supremacy Clause bars claims under the FTCA-a federal statute enacted by Congress when the negligent or wrongful acts of federal employees have some nexus with furthering federal policy and can reasonably be characterized as complying with the full range of federal law. Whether the FTCA's discretionary-function exception bars claims for torts arising from wrong house raids and similar negligent or wrongful acts by federal employees. Justice Gorsuch delivered the opinion for a unanimous court. Justice Sotomayor filed a concurring opinion, in which Justice Jackson joined.
Justice Gorsuch's unanimous opinion. On October 18, 2017, the FBI raided the wrong house in suburban Atlanta. Officers meant to execute search and arrest warrants at a suspected gang hideout at 3741 Landau Lane, but instead stormed 3756 Denville Trace, a quiet family home occupied by petitioners Hilliard Toy Cleott, his partner Katrina Martin, and her 7-year-old son. A 6-member SWAT team breached the front door, detonated a flashbang grenade, and assaulted the innocent occupants before realizing their mistake. The cause of the error was Special Agent Guerra's reliance on a personal GPS device, combined with the team's failure to notice the street sign for Denville Trace and the house number visible on the mailbox. Left with personal injuries and property damage, petitioners sued the United States under the Federal Tort Claims Act, FTCA, seeking damages resulting from the officers' alleged negligent and intentional actions during the raid. The district court granted summary judgment to the government. The 11th Circuit affirmed, applying a unique approach to FTCA claims. The FTCA waives the federal government's sovereign immunity from suit as to certain torts committed by federal employees acting within the scope of their employment. But that waiver is subject to statutory exceptions, including two relevant to a law enforcement misconduct case like this one. The first is the intentional tort exception in Section 2680H, which bars claims against the government for 11 enumerated intentional torts. The second is the discretionary-function exception in Section 2680A, which bars claims against the government that are based on an official's exercise of discretionary functions. Section 2680H also contains a law enforcement proviso which countermands the intentional tort exception, allowing suits for 6 specified torts, including assault, battery, false imprisonment, and false arrest, to proceed against the United States when the torts are committed by investigative or law enforcement officers. While most courts hold that the law enforcement proviso applies only to the intentional tort exception, the 11th Circuit's approach is different in 2 key respects. First, the 11th Circuit alone holds that the proviso overrides all exceptions in Section 2680, including the discretionary function exception, meaning that intentional tort claims covered by the proviso automatically proceed to the merits without further analysis of other applicable Section 2680 exceptions. Second, to compensate for this plaintiff-friendly approach, the 11th Circuit permits the government to assert a restrictive Supremacy Clause defense at the liability stage, allowing the government to escape liability when an officer's actions have some nexus with furthering federal policy and reasonably comply with the full range of federal law. Applying its distinctive approach, the 11th Circuit held that the law enforcement proviso protected petitioners' intentional tort claims from both the intentional tort and discretionary function exceptions. The court dismissed petitioners' negligence claims under the discretionary function exception, reasoning that Special Agent Guerra enjoyed discretion in preparing for the warrant execution. On the merits of the remaining intentional tort claims, the court found the government had a valid Supremacy Clause defense and granted summary judgment for the United States. Held 1. The law enforcement proviso in Section 2680H overrides only the intentional tort exception in that subsection, not the discretionary function exception or other exceptions throughout Section 2680. A. The text and structure of Section 2680 demonstrate that the law enforcement proviso applies only to the intentional tort exception. The proviso appears within the same subsection and sentence as the intentional tort exception, reflecting the established principle that statutory provisos generally modify only the provisions in which they appear. Section 2680 contains 13 discrete exceptions. Coupled with the lead-in clause, each exception forms a separate sentence and operates as a structurally distinct provision. The proviso addresses the same subject matter as subsection H, intentional torts, while other exceptions cover entirely different topics like lost mail, combat injuries, and quarantine impositions. Further, the proviso's definitional sentence expressly limits the definition of investigative or law enforcement officer to this subsection, i.e., subsection H, even though the phrase law enforcement officer appears elsewhere in Section 2680. Congress's choice to embed the proviso within subsection H rather than place it at the end of the full list of exceptions, as it sometimes does with broadly applicable provisos, further confirms the proviso's limited application to subsection H alone. B. Petitioners' arguments for broader application of the proviso are unpersuasive. While the proviso mirrors the language of Section 2680's lead-in clause by stating that Section 1346B shall apply rather than shall not apply, this textual similarity does not demonstrate that the proviso applies to all exceptions, which form discrete instructions that may be understood completely without reference to other provisions. The absence of limiting language in the proviso's first sentence does not expand its scope beyond subsection H, as Congress accomplished that limitation through the proviso's placement within the same sentence as the intentional tort exception. Legislative history suggesting Congress intended to address wrong house raids broadly cannot displace what the law's terms clearly direct, as legislative history is not the law, and members of Congress may have had multiple purposes in mind when crafting the proviso. 2. The Supremacy Clause does not afford the United States a defense in FTCA suits. The FTCA is the supreme federal law governing the United States tort liability and serves as the exclusive remedy for damages claims arising from federal employees' official conduct. The statute generally makes the government liable under state law on the same terms as a private individual would be liable under the law of the place where the tortious conduct occurred. Because the FTCA incorporates state law as the liability standard, there is typically no conflict between federal and state law for the Supremacy Clause to resolve. While federal law may sometimes displace state law in FTCA suits where a constitutional text or federal statute supplies controlling liability rules, the 11th Circuit identified no such federal statute or constitutional provision, displacing Georgia tort law in this case. The court's reliance on In re Neagle 135 is misplaced, as that 19th century decision involved a federal officer's immunity from state criminal prosecution for acts necessary and proper in discharging federal duties, not the federal government's liability, under a statute that expressly subjects it to state tort law on the same terms as private parties. Section 2674 specifies the defenses available to the government, including judicial or legislative immunity and other defenses to which the United States is entitled, but these do not include the 11th Circuit's novel Supremacy Clause defense. 3. On remand, the 11th Circuit should consider whether subsection A's discretionary function exception bars either the plaintiff's negligent or intentional tort claims, undertaking that assessment without reference to the mistaken view that the law enforcement proviso applies to subsection A. The court must then ask of any surviving claims whether, under Georgia state law, a private individual under like circumstances would be liable for the acts and omissions the plaintiffs allege, subject to the defenses discussed in Section 2674, not a Supremacy Clause defense. Remaining questions surrounding whether and under what circumstances the discretionary function exception may ever foreclose a suit like this one lie well beyond the two questions the court granted certiorari to address, and their resolution would benefit from the 11th Circuit's careful re-examination of this case in the first instance. Vacated and remanded.
Justice Sotomayor's concurring opinion. I join in full the court's opinion, which holds that the 11th Circuit's distinctive approach to suits under the Federal Tort Claims Act, FTCA, is wrong in two respects. The law enforcement proviso modifies only the subsection in which it is located, Section 2680H's intentional tort exception. The United States, moreover, may not defeat an FTCA suit simply by showing that a federal officer's acts had some nexus with furthering federal policy and complied with the full range of federal law. Alteration in original. With those two principles clarified, I also agree that the 11th Circuit must now consider on remand whether the FTCA's discretionary function exception bars plaintiffs' negligent and intentional tort claims. I write separately to underscore that there is reason to think the discretionary function exception may not apply to these claims. The FTCA shields the United States from liability for claims based upon a federal employee's exercise or performance, or failure to exercise or perform a discretionary function or duty, whether or not the discretion involved be abused. This court has set forth a two-part test that governs the application of Section 2680A, known as the discretionary function exception. First, courts must consider the nature of the official's conduct and decide whether it involves an element of judgment or choice. The requirement of judgment or choice, this court has explained, is not satisfied if a federal statute, regulation, or policy specifically prescribes a course of action for an employee to follow. In such circumstances, the employee has no rightful option but to adhere to the directive. Even where a federal employee retains an element of choice, however, the exception does not apply reflexively. After all, it is rare for statutes or regulations to prescribe an official's required course of conduct down to the very last detail, so some degree of choice will almost invariably remain. Thus, this court has required lower courts to determine at the second step whether the judgment is of the kind that the discretionary function exception was designed to shield. Because the basis for the discretionary function exception was Congress' desire to prevent judicial second-guessing of legislative and administrative decisions grounded in social, economic, and political policy through the medium of an action in tort. This court has clarified that the exception protects only those governmental actions and decisions that are themselves based on considerations of public policy. To that end, this court has said, it is obvious that some discretionary acts performed by government agents are within the scope of their employment, but not within the discretionary function exception. If a federal banking regulator drove an automobile on a mission connected with his official duties and negligently collided with another car, for example, the court has made clear that the exception would not apply. That is because while driving requires the constant exercise of discretion, the official's decisions in exercising that discretion can hardly be said to be grounded in regulatory policy. It has been 34 years since this court last weighed in on the discretionary function exception. And despite substantial percolation in the courts of appeals, the exact boundaries of the exception remain unclear. The court today resolves one of the circuit splits regarding the exception's application, whether claims that fall within the FTCA's law enforcement proviso must necessarily fall outside of the discretionary function exception. Yet, as the court recognizes, several additional points of disagreement remain, including whether allegedly unconstitutional conduct necessarily falls outside the exception, because officials lack discretion to violate the Constitution, and whether the exception applies when the challenged act was careless rather than a considered exercise of discretion. Given the enduring questions about how to apply the discretionary function exception and the divergent approaches taken by the circuits, it is long past time for this court to weigh in on the exception's scope. Even without further intervention by this court, however, there is reason to question the 11th Circuit's suggestion in the decision below that the discretionary function exception might apply unless a source of federal law specifically prescribes a federal employee's course of conduct. That approach, which even the government does not defend before this court, would run headlong into this court's precedents. Gobert, after all, applies the discretionary function exception only where an official's actions both involve an element of judgment and rely on public policy considerations. Whether federal law prescribes a particular course of action resolves only the first of Gobert's two questions. The second question, whether an officer's decisions were based on considerations of public policy, remains live. Were it otherwise, a federal official's negligent driving decisions would fall beyond the reach of the discretionary function exception only if federal law or policy specifically prescribed an officer's permissible maneuvers on the road. Agent Guerra's preparation to execute search and arrest warrants at 3741 Landau Lane and his subsequent decision to raid Martin and Cleot's home at 3756 Denville Trace bear some resemblance to Gobert's negligent driving hypothetical. Like driving, executing a warrant always involves some measure of discretion. Yet it is hard to see how Guerra's conduct in this case, including his allegedly negligent choice to use his personal GPS and his failure to check the street sign or house number on the mailbox before breaking down Martin's door and terrorizing the home's occupants, involved the kind of policy judgments that the discretionary function exception was designed to protect. The FTCA's history, too, confirms Congress's intention to subject the United States to liability for intentional torts committed by law enforcement officers like Agent Guerra. The relevant context is as follows. For several decades after the FTCA's enactment, Congress retained the United States sovereign immunity for myriad intentional torts committed by federal employees, including assault, battery, and false arrest. That changed, however, in response to an episode that will sound familiar to readers of the majority opinion. In April 1973, Herbert and Evelyn Giglotto awoke in their Collinsville, Illinois townhouse to the sound of someone smashing down their door and bursting into their house. After 15 state and federal officers ransacked the Giglotto's home, tied them up at gunpoint, and threatened to shoot Mr. Giglotto if he moved, the officers realized they hayed the wrong people. The officers eventually moved on to the home of Donald Askew, where they terrorized yet another innocent couple before confessing they had acted on a bad tip. The Collinsville raids garnered national attention, including from the United States Senate, noting that there was no effective legal remedy against the federal government for the actual physical damage, much less the pain, suffering, and humiliation to which the Collinsville families had been subjected. The Senate Committee on Government Operations proposed an amendment to the FTCA. The solution was to add a proviso to the end of the intentional tort exception that deprives the federal government of the defense of sovereign immunity for FTCA suits arising out of the state law torts of assault, battery, false imprisonment, false arrest, malicious prosecution, or abuse of process by federal law enforcement officers. The committee designed the proviso to ensure innocent individuals who are subjected to raids of the type conducted in Collinsville, Illinois, will have a cause of action against the individual federal agents via suits under Bivens v. 6, Unknown Fed, Narcotics Agents. Of course, the majority correctly holds that the proviso does not altogether trump the discretionary function exception. Even if an intentional tort claim survives its encounter with subsection H, thanks to the law enforcement proviso, courts must nevertheless consider whether subsection A's discretionary function exception bars the plaintiff's negligent or intentional tort claims. Courts, however, should not ignore the existence of the law enforcement proviso or the factual context that inspired its passage when construing the discretionary function exception. Whatever else is true of that exception, any interpretation should allow for liability in the very cases Congress amended the FTCA to remedy. On remand, the court should approach the discretionary function exception with an eye to both steps of the Gobert analysis and to the existence and context of the intentional tort exception's law enforcement proviso.
Case implications. This decision has two possible real-world consequences that may reshape how victims of federal law enforcement misconduct can seek justice. First, the court significantly narrowed the pathway for lawsuit victims in most federal circuits. Before this decision, the 11th Circuit had a unique two-step approach that was actually more favorable to plaintiffs in certain ways. While the 11th Circuit made it harder to win at trial with their restrictive Supremacy Clause defense, they also allowed intentional tort claims to bypass the discretionary function exception entirely. Now, victims everywhere must navigate both the intentional tort exception and the discretionary function exception. This means that even in cases involving clear police misconduct, like raiding the wrong house, victims might still lose their cases if courts determine the officers were exercising discretionary functions. The discretionary function exception has been notoriously difficult for courts to apply consistently, and this decision ensures it remains a significant hurdle for plaintiffs. Second, the court eliminated a powerful government defense but left victims facing an uncertain future on remand. By rejecting the 11th Circuit's Supremacy Clause defense, the court removed the government's ability to escape liability simply by showing an officer's actions had some nexus with furthering federal policy. This should make it easier for victims to win their cases once they get to trial. However, the court explicitly refused to clarify how broadly the discretionary function exception should apply to law enforcement cases. This means the Martin family and future victims of wrong house raids must return to the lower courts without clear guidance on whether their specific type of case can proceed. The court essentially kicked this crucial question down the road, leaving victims in a state of legal uncertainty about whether they'll even get their day in court. Now, those implications might make you wonder, could we have seen this coming? That's one of the things I love most about following Supreme Court cases. The oral arguments often give us a sneak peek at where the justices are headed, though sometimes they surprise us. So let's dive into the oral argument tea leaves. I went back through the transcript and audio to see how the justices' questions and reactions during argument matched up with their final written opinions. And what I found was a mix of totally predictable outcomes and some divergence, particularly as it involved the scope of the court's opinions. The big question is, when can we trust what we hear at oral argument to predict the outcome, and when do the justices keep their cards closer to their chest? Let's break it down. Let me start with the obvious. During oral argument, the justices were clearly skeptical of the plaintiff's argument that this law enforcement proviso should override almost every exception in the Federal Tort Claims Act. Justice Sotomayor put it bluntly, "What you're asking us to do is to say 11 of the 12 other exceptions are still operative, but only this one isn't." And sure enough, the court unanimously shot down that broad interpretation. Justice Gorsuch's majority opinion used the exact same reasoning we heard at oral argument, that when Congress tucks a provision inside one specific section, it usually only applies to that section. It's like when your mom writes a grocery list and puts "if on sale" next to steak, she doesn't mean buy everything else, only if it's on sale too. The other area of forecasting? The Supremacy Clause defense was toast. The government basically threw in the towel during oral argument, conceding they wouldn't even defend the 11th Circuit's approach. When Justice Kavanaugh said, "We can say the Supremacy Clause is not a bar," it was game over. But here's where things got interesting. During oral argument, the justices peppered the advocates with questions about the discretionary-function exception. That's the rule that protects the government from lawsuits when federal employees are making policy judgments rather than just following orders. Justice Sotomayor was all over this issue. She pressed both sides about whether Agent Guerra's decision to rely on his personal GPS and ignore street signs was really the kind of high-level policy decision this exception was meant to protect. She compared it to a federal employee negligently driving a car. Sure, driving requires discretion, but crashing because you're not paying attention isn't a policy decision. Notably, Justice Gorsuch's opinion basically said, "Nope, not today." The majority opinion explicitly punted on this issue, saying it was beyond what they agreed to decide, and the lower court should figure it out first. That left space for Justice Sotomayor's concurrence to fill. She wrote a separate concurring opinion that basically said, "Fine, if we're not going to resolve this now, at least let me give everyone a roadmap." Her concurrence was like the detailed analysis many of us expected from the main opinion. She walked through the two-part test courts use for the discretionary-function exception and strongly hinted that Agent Guerra's conduct, using the wrong GPS, ignoring street signs, not checking the house number, looks a lot more like careless mistakes than protected policy judgments. She also reminded everyone why Congress created this law enforcement exception in the first place. Back in 1973, federal agents raided the wrong house in Illinois, terrorized an innocent family, and Congress was so outraged, they changed the law to make sure victims could sue. Her message was clear: whatever this discretionary function exception means, it shouldn't swallow up the very cases Congress wanted to allow. The Martin family still has to go back to the lower court. But they've got a much clearer path forward thanks to this decision, and especially thanks to Justice Sotomayor's roadmap for navigating the discretionary function exception. That's it for Martin. Hope you enjoyed. If so, please follow, share, and review. We're halfway through today's opinions. Let's next turn our attention to Parrish v. United States.